Justice Cohen, good morning, welcome. You may proceed, good morning.
Good morning, Your Honors. May it please the Court, my name is Donna Aldea, and I represent Mayor Herskovic. Your Honors, when courts talk about a disturbing feeling that an innocent man has been convicted, this is the poster child case for that sentiment. This is a case where there was absolutely no evidence placing Mayor Herskovic at the scene of the assault.
Counsel?
There was, yes.
I'm troubled with respect to the due process issue. If you had wanted to, could you have tested the sample, the DNA sample, as a defense attorney? And could you have compared it to other members of the Hasidic community?
I would not have been able to have compared it. We would not have been able to have compared it to other members because that would require getting DNA profiles. We would have had access to the DNA sample. However, in this case, that was very complicated here. And the reason for that, which actually goes into the ineffective assistance of counsel or due process claim, is that in this case, the people, even though they got the DNA results 2 years before the commencement of this trial, and even though the discovery was timely requested, the people did not turn over the discovery for that DNA evidence until literally the eve of trial. Literally the eve of trial.
Do we have any knowledge as to why that would be the case?
No, Your Honor. I actually do have some knowledge, although it's not on the record. The knowledge is that
You know what happens with that, right?
Well, I can answer the question, but I'm telling you in advance. The knowledge.
Was there an application? Obviously there was an application for it.
Correct.
Well before then.
Correct. The application was a timely application.
On the record, what did the district attorney say about turning this over on the eve of trial, which was very significant, let's say?
What the record shows is that counsel, in a letter to the court on the eve of trial, showed that he had made every attempt to obtain the evidence. He had made phone calls to the district attorney's office, written letters to the district attorney's office, sent emails to the district attorney's office, and his exact quote in that letter he submitted to the court was, they were all ignored. Then counsel asked...
There was never a response?
No, the response was on the court appearance, which was supposed to be the first day of trial, the evidence was turned over. That was the only response he got. At that point, counsel said, whoa, this is a lot of stuff I'm getting here.
And then he got a one-week adjournment.
He got a one-week adjournment. Now, counsel followed that up with a letter saying that 1 week was not sufficient for him. And in fact, actually, I think the people's brief elucidates more than anything else how insufficient it was. This is a case that was dealing with two relatively novel, or at least recently challenged, scientific techniques.
FST, HST.
Correct, Your Honor. And in this case, there was a hearing that had been held just down the hall from this courtroom where this trial was taking place recently that had found that those two techniques were actually insufficiently reliable under Frye to even allow for their admissibility at trial. In
your brief, you indicate, and is this accurate, that the use of FST and or HST as a tool, if the district attorney wanted to upload this to CODIS or to the FBI back then, never mind today, could they have?
No.
Why?
Because it was insufficiently reliable to allow comparison. In fact,
and it was that convicted this defendant?
Correct. But it's even worse. In this case, it's far worse than even that. But to fully address Your Honor's question, both of those techniques individually had issues. So HST, which is high sensitivity testing, is a technique by which what the people did in this case, and I'm not talking about all high sensitivity testing, but what was done in this case was that they actually had an insufficient amount of DNA once they quantified it in that first stage. And that amount was under the 101 picograms that is required to allow for testing under the test kit that they were using. So their analyst, Troy Holder, actually...
It was something like 97.9.
Correct, Your Honor.
So it was close but no cigar.
Correct. And their analyst actually testified at trial that when they have a situation like that, most labs in the country would say, we don't have enough here to test, so we're not going to do it. The OCME created its own protocols for doing it, and what they did, the exact testimony from the people's experts, they used the same test kits by which the manufacturers say that is not a reliable result, and they, quote, tweaked the protocols to allow them to run this result. So that's the first reason that this is not admissible into CODIS. It is not uploadable into CODIS and was not, which accounts for, in fact, the OCME subsequently changing its protocols and withdrawing these in favor of a different test. The second reason is that the FST databank doesn't even generate a profile. That's the part of this case that is most disturbing. This is a case that not only is there no physical evidence, there's no identification, no statement, no cell sites, no corroborating evidence placing him at the scene, but what I find most disturbing is we're calling this a DNA case. The people's summation said this was a DNA case. Counsel argues that this is a DNA case. There was no DNA evidence in this case. The people's own expert testified that there was no match. That is a quote. This was a non-deducible mixture. So when Your Honor asks about could this be uploadable, FST is a statistic. It's a statistic that doesn't generate a profile, so there isn't even anything to upload. The combination of those two things in this case rendered these statistics and the proof at this trial entirely meaningless. And
So
that
why
was
don't we
people's
go to
only
the
proof.
statistics, all right?
Excuse me, Your Honor?
Go to the statistics. Why don't you tell us, if you can, why the statistics alone is insufficient?
Yes. So in this case, what FST does, it is a data bank that actually was created by the OCME. The source code for that data bank was never released, and it was subject only to OCME protocols, OCME's own internal validation methods. Now, since that time, and what the court has available to it through purposes of research, what happened with FST, with that data bank, that data bank consists of approximately 400 profiles. That's it. So when you're talking about the universe of how many people, 8 billion people on this planet, you're talking about a very limited data bank that contains only approximately 400 profiles. Of those, I'm sorry, it's less than 400. I think I misspoke. I think it's 80 profiles. Of those, they created mixtures that generated only a total of somewhere around between 400 and 600 mixtures. That is the data bank, the universe from which these statistics are drawn. So that's why Judge Dwyer in People versus Collins and Peaks actually found that this is insufficient to pass muster under Frye, not only because there are no internal or there are no external protocols or external validation studies, but because the universe was so limited. Here, that's even more exacerbated because we're dealing with a very closed universe of possible assailants. This is a data bank that tests for, in general, the general population. There's nothing in the data bank that filters or allows for a filter for purposes of having closed communities. Here, the universe of possible assailants was limited to Hasidic Jews from Williamsburg. That has been identified. It's one of probably the most insular communities in terms of shared ancestry. So when we go online and go on Ancestry.com and we can figure out where we're from, well, that's because we share DNA with common ancestors. When you have a closed and insular community, the likelihood of those members of the community having common DNA, which I think goes to your question initially, right? That likelihood of having this shared DNA is not accounted for by these statistics.
Were the
Now,
other people who were arrested, I think there were 3 or 4 other individuals arrested, did they submit DNA?
they did submit DNA samples, and we have no idea what those results were. The people never disclosed those in discovery. So we simply
Not part
don't
of this
know.
record.
Now, when the statistics were run, what FST does, the analyst admitted, it cannot generate a DNA match. It's simply incompetent to do that.
So just going back before you finish, and I know you're moving on to the next important subject.
I'm actually still trying to answer your Honor's question.
Okay,
Yes.
but the essence of what you're saying is, no matter what the statistical analysis is, reliable or not, and there are those who say it's totally not reliable, including apparently the FBI and CODIS, the numbers are even more unreliable because it's such an insular community.
Correct, Your
And we don't have anything about that.
Nothing. And in fact, what we do know is that that data bank with those limited number of profiles and matches, we don't know if there are any Hasidic Jews in it. We know that of all the possible combinations, only 11 combinations in that entire data bank deal with people of the same race, let alone people of the same ancestry. So it is a
There are
database.
significant differences between, say, Asians and whites and blacks when you put in the DNA material, right?
Correct, Your Honor. There can be. There's a much greater likelihood of having shared alleles or having shared genetic profiles as a result of that. Interestingly, though, in this case, actually Mayor Herskovic and Taj Patterson, who were of different races, actually had a lot of shared alleles when you look at the chart, which is interesting, too.
Is an allele, if you, in simple terms?
Yes, an allele is at every location or loci that they look at in running a DNA test on this DNA molecule, each person contributes or has a total of 2 alleles. That's a number. When you look at it on the chart, it's a number, like 12, 13, it could be.
Is that one from the mother and one from the father?
Exactly, Your Honor. One comes from the mother, one comes from the father. So each person will have 2 at each location.
And each allele has several genetic traits on it? Or is
Yes, it can. It can account for several, each loci can account for several genetic traits. But the portion that they look at here isn't really a portion that accounts necessarily for traits. It's just locations on the molecule that they look at for purposes of generating the chart. Here, we looked at a total of 15. Now, to further answer Your Honor's question about the statistics in this case and why they were meaningless, putting aside that the general unreliability that some courts have found, like in the Collins-Peaks decision, which was very thorough and very well analyzed after a very long hearing on this point. Putting that aside, the way that the test was conducted in this case was particularly disturbing. What happened in this case, and I think the best way to look at it is to look at the charts that I provided in the briefs on page 35 of the brief. What happened in this case is that the analyst acknowledged that FST testing, which really is just statistics, like I said, it doesn't generate a DNA match, it's not truly scientific
Just to make it
evidence.
clear, if I'm not mistaken, there was no DNA match.
No, not
as
at all.
as we say. Like 1 out of a quadrillion is a number I hear very often in DNA.
probability.
It's not a match at all. It's just it's a statistic.
Not a match at all. And in fact, the people's experts testified there is no match in this case, and quote, the FST does not provide a match. It does not substitute from the absence of a deducible mixture from which a match can be made. That's the people's own experts acknowledge that. So here's
And this was you didn't mention that it is a deducible
it's
mixture.
not. It's a non-deducible.
Non-deducible. What does that mean?
It means it is a mixture from which no deduction can be made. In other words, there was no DNA match. There was no way to say that Mayer's DNA was on that shoe. That's the fundamental problem here, and that's why I started by saying we're calling this a DNA case, but it's not. It's a non-DNA case.
At some point, you're going to have to come to me. You know that I've been
Yes,
trying
Your
to
Honor.
not interrupt you. I've been very, very subtly trying to wave my hand. As soon as you're done with my colleagues to my right, your left, come to me.
Yes, Your Honor. Okay, so here's the problem with the fallacy that the analyst engaged in. What the analyst did here is he explained that what FST does is it allows for an analyst to create 2 possible scenarios and then to say what is the likelihood ratio that one scenario that is analyst defined is more or less likely than a second scenario that is also analyst defined. So the analyst admitted that obviously the reliability of that statistic, of that probability, depends fundamentally on whether the analyst is defining fair scenarios or good scenarios. Well, here's what the analyst did in this case. The analyst started by saying, we're going to assume that this is a 2-person mixture. Now, if you look at the charts on page 34 and 35 of the brief, what you'll see is that a 2-person mixture really seems impossible because there are
5, right?
5 alleles at many of the locations. So you can't possibly, if you have only 2 people contributing, you can't possibly wind up with 5 alleles. The most you can get is 4, okay? So that assumption was not necessarily valid. So what the analyst did is the analyst said, okay, but that's okay, because some of these alleles are what he called, quote, fluke alleles. So he explained that because high sensitivity testing is somewhat unreliable, which is ironic actually, because high sensitivity testing is somewhat unreliable and allows for fluke alleles or fake alleles to show up in the composites, drop-ins and drop-outs and stutter and other kinds of defects. What they do at OCME to try to make it more reliable, to tweak the protocols, is they do 3 runs of the same DNA batch. So what the analyst said is, we're going to look only at the alleles that repeat in 2 out of the 3. The other ones are unreliable fluke alleles. We're going to ignore them. So that's how the analyst started by saying, okay, so now I've gotten rid of those unreliable alleles because they don't repeat in 2 out of 3. So now I'm left with at most 4 alleles at each location. It's a 2-person mix. That's assumption 1. That's fine. The problem is that the analyst then, when he looked at those fluke alleles, when he removed those fluke alleles, got a profile that when you take out Taj Patterson, the victim's DNA from it, it is inconsistent with Mayor Herskovic. Not just a little bit inconsistent. 11 out of 15 locations inconsistent. In other words, when you subtract out the victim's unique DNA profile, what you're left with at 11 out of 15 locations is a profile that cannot be Mayor. Both because at those locations there are some alleles that are there that Mayor doesn't have, which means there had to have been at least a 3rd contributor because the victim didn't have them and Mayor didn't have them, so it's clearly not either one of them.
But didn't the people's expert testify that if you have 3 or 4 other individuals, it would not impact on it actually would be better in terms of pointing to?
Your Honor, the victim, the people's expert, frankly, was simply not confronted with this evidence. And part of the reason he was not confronted with this evidence was because the DNA was turned over so late and because the defense attorney simply did not have time to consult with an expert. On that point, the people's brief makes the best point. They acknowledge that after the whole people's case had been concluded, at that point, the defense attorney sent a letter saying, I finally got an expert, I need to call this expert, the conclusion of the people's case. And he furnished a letter saying that there was a case on point that dealt with star mix or STR mix, which was on point, he claimed. As the people point out, that wasn't even the test that was used here. So because of the timing of the disclosure, whether you want to call that an ineffective assistance of counsel claim, a due process claim, I really think in fairness to the defense attorney, it should be a due process claim because it's really the people's fault here. But in any event, whatever you call that, the reason that that didn't come out at trial is because he never confronted the people's expert with it. So when they say that the people's expert testified that this is fine, it's not a problem, this is, the way that it can be done, that's simply not accurate. There was no meaningful cross of that expert, no confrontation. And the charts in the brief, which is what I compiled based on the testimony of the expert, clearly shows the fallacy he should have been confronted with. But this court also is not bound to throw common sense out just because an expert testified, oh, this is the way that it can be done and this was just as good. In fact, what we did have at this trial...
Was a continuance requested by the defense in order for a proper review/prep of the intended defense expert witness?
Yes, Your Honor, it was.
What happened with that?
It was,
It's a rhetorical question. Just answer it anyway, please.
Denied. He was granted 1 week. He was essentially granted 1 week, which he said was insufficient to allow for it. Then actually what happened is he did call an expert. That expert got on the stand, was challenged by the people, and the trial court actually wrongly denied him expert status, which he should not have done. It should have gone to wait. At that point, the defense was left scrambling with literally 1 day left to find a new expert. And I think that expert it was one of the experts who had also testified in Collins Peak, so a good expert. However, it was an expert who had less than a week, literally a couple of days, to review all of the testimony in this case. Now, that expert testified that these results were meaningless. So the court, in weight of the evidence review, can certainly rely upon that. But just to finish the thought, and I know it's a little bit complex, but what the expert did, what the people's analyst did in running the FST, I started by saying he started with this kind of unreasonable assumption that it's 2 people. But even assuming that that's okay, what he did next is absolutely staggering. What he did next is he said, okay, I've gotten rid of the unreliable fluke alleles to assume this is a 2-person mix. But now I'm left with a profile that can't possibly be Mayor because when you get rid of the victim's DNA at 11 of 15 locations, it's not a match. So what he did is he added in all of those alleles that he had previously said are unreliable, are flukes, can't be considered. And when he added them back in, he ran the FST likelihood ratio. So in other words, he relied on 2 entirely inconsistent scenarios in setting up his questions. First, he said, we're going to assume this is two people. Then he added in the alleles that made it impossible to be two people. That's why the defense expert said this is simply meaningless. And that simply cannot be relied on to create any kind of result.
Can you explain something to me? I see two statistics here. 1 out of 133 and a statistic involving the number 635,000, which is strong evidence of something. What?
Okay. So the first statistic, the first test, because remember the expert runs these two different scenarios against each other. So the first scenario is the expert said, okay, so I've got this DNA mix, this non-deducible mixture. Is it more likely that this mixture contains Mayor Herskovic's DNA and an unknown, or two unknown people from the general population? When he ran that statistic, what he got is that it was 695,000 times actually more likely.
I apologize.
That's okay. 695,000, equally meaningless, 695,000 times more likely that the mixture was Mayor and an unknown rather than two unknowns.
Why is that significant or not significant?
It's not significant because it's asking the wrong question. First of all, there was never a possibility that this was Mayor and an unknown. We knew that the victim's DNA was going to be on the victim's own sneaker. And in fact, the victim actually, his alleles, his exact alleles, appear at every single one of the locations here. Plus, the analyst admitted that he just assumed, he had to assume that the victim's DNA would be there. So it's meaningless. It's a meaningless statistic for that reason. It's additionally meaningless because if we're looking at Mayor versus Mayor and an unknown versus two unknowns, that also defines the parameters wrong because that was never our suspect pool. We're not talking about 8 million possible suspects from all sorts of genetic backgrounds. We're talking, again, about an insular community of Hasidic Jews from Williamsburg, Brooklyn. So if you want to ask the question correctly, the question should be, is it more likely that this is Mayor's DNA than another Hasidic Jew from the same community?
And we don't know the answer to that.
Have no clue. Now, the other thing that happens, actually, which is interesting, the second statistic that Your Honor asked about was the analyst next said, okay, so I have this number, 695,000 times more likely that it's Mayor and an unknown versus two unknowns. The next scenario he posits is it more likely that this is a mixture of Taj Patterson, the victim, and Mayor, or Taj Patterson and an unknown? Now what happens, which is interesting, and that's why that 695 actually hurts the people, not helps them. Once you factor in the victim, who was never a question to begin with, you knew his DNA was going to be there, the likelihood ratio drops precipitously, even based on the flawed and skewed analysis that the people's expert used in this case. Now it drops to only 133 times more likely that the mixture is Mayor and the victim as opposed to the victim and an unknown. Now, in the universe, even putting aside all this argument that I've done and all the argument that I'm about to do, when we talk about DNA matches, when we talk about proof beyond a reasonable doubt stemming from a DNA comparison,
It's one in a quadrillion.
Yes, it's 1 in a quadrillion. We're talking about 1 in 133.
Without analyzing the Hasidic factor.
Exactly.
Which would reduce that 133 to who knows what.
Who knows
it wouldn't
what?
increase it. It would have to reduce it.
Absolutely. If someone told me that I had a 1 in 133 chance of getting on a plane and dying, I wouldn't board the plane. But we've taken away a man's freedom based on nothing more than that one statistic.
What other evidence was there beyond this, what you call paucity of evidence? What else was there?
Nothing. Nothing.
No ID.
No ID.
No statement.
Nope. No cell sites, no fingerprints, no nothing.
Weren't there even questions as to whether or not the victim in this case identified one of the ringleaders originally as the person who actually thrust his finger into his eye, and then in the grand jury at the beginning of these proceedings, and then later changed his testimony regarding that?
Yes, Your Honor. In fact, in this case, when we talk about a paucity of proof, I actually think what's interesting, and I've never, in 20 years of practice, I've never seen this. I've never seen a case, a people's case, prosecution case, that was exculpatory for the defendant and implicated people very clearly who the DA's office never even charged, never arrested, never investigated, never charged. What happened at this trial is that here, the testimony from the victim was that he was, initially what happened is he was walking down the street pushing in mirrors.
No need to marshal the facts. We know the
I
record.
won't, Your Honor. But there are 3 people that gave chase, and the victim testified.
Initially.
Initially, correct.
And this is on surveillance, right?
On surveillance. And the victim testifies at trial even that of those 3 people were at the center of the assault, and those 3 people, aided by 2 others who were holding his arms, contained the ringleader. Now, the ringleader is the only person who caused serious physical injury in this case. He's the one who both shoved his thumb in the victim's eye, kicked him in the head, which caused him to go blind in one eye, and significantly
Remove the sneaker.
removed the sneaker and threw it. So the ringleader, we have the 3 people on surveillance video. None of those 3 people was Mayor Herskovic. Not one, and not one of them was arrested and charged by the prosecution.
Is that fact or that conclusion drawn from the record disputed by your learned colleague on the people's side?
No, it is absolutely not. The next
The
thing...
actual assault is not on the video, though.
The assault is not on the video. The next thing that happens is that the victim testifies. He's testifying to the facts of the assault and testifying to the ringleader. And the victim testifies that during the assault, he actually punches and he makes contact with the ringleader's face. And he said, his quote was, "I hit him really hard." So he made contact hard. Now, he wasn't able to make an identification at trial. However, we had other eyewitnesses. Wolf Herskovic, who interestingly was also a people's witness, a prosecution witness in this case, testified that he saw the assault. And what he saw is Joel Iskowitz, who, by the way, was one of the 3 people that is seen on the surveillance running. Joel Iskowitz was at the center of the fray, and he saw the victim pull his hand free and make contact with Iskowitz's face, breaking his glasses. So when you put the eyewitness evidence together with the surveillance, with the victim's testimony, what you get very clearly is that Iskowitz was the person that was the ringleader of this assault.
Don't you also have a witness, I believe it was Guzman, who said it was a person in the jacket with an emblem, arguably somebody from the Shamroon Patrol, tossing the sneaker?
Yes, Your Honor. And interestingly, that is exactly what Joel Iskowitz was wearing on the video surveillance. He was wearing a navy blue windbreaker with a yellow Shomrim emblem with the radio that Guzman also described, and so he perfectly matches, again, another corroborating piece of evidence that that was the ringleader. What's more, as Your Honor pointed out before, the victim did acknowledge at trial that in the grand jury, when his memory was fresher, he couldn't make an identification of who the 3 were, who the ringleader was, but he did testify and acknowledge at trial that Mayor Herskovic was not the ringleader and was not one of those people that was chasing him.
Is there any evidence that, I'm sorry. Is there any evidence?
Your Honor, I am still getting back to you.
I'm sorry.
After this
Yeah.
45-second exchange, you're coming to me.
Any evidence that the defendant was a member of the Shomrim or was the ringleader? Was there any evidence whatsoever?
No, Your Honor.
adduced?
There was no evidence that he was a member of the Shomrim. And actually, while I would not rely on off-the-record evidence before this court, one of the things I found very troubling, and I did point it out in the reply, is that the insinuation, there was no evidence about defendant being a member of the Shomrim. In the People's Brief, what they did is they basically insinuated that the defendant might have been the person in the Shomrim jacket that Guzman identified or that Guzman described. And the answer to that is the people know from their own independent investigation that not only was there no evidence, the reason there was no evidence that Mayor was in the Shomrim is because, in fact, he was not in the Shomrim. And they know that through their independent investigation that is clear from the discovery material that is provided. So while it's true that I can't rely on the off-the-record fact to establish that, nor can the people claim that the defendant had some burden of proof in showing otherwise, and nor can the people posit before this court a theory that is inconsistent and not supported by what they know to be the truth. Because in the end, they have to maintain justice. They have to uphold justice.
45 seconds
Yes,
are
Your
up.
Honor.
Justice Austin has a quick question, and then I have one question subdivided into 4 aspects.
Yes, Your Honor.
And that's the end of that, because you are beyond the 30-minute mark. Go ahead.
Yes, Your Honor.
Mine won't be subdivided. The sneaker was thrown onto the roof,
Yes.
and it remained there for about 6 days, as I recall.
Correct.
Was there any testimony or proof with regard to the quote-unquote quality of the DNA, or whether it degraded as a result of sitting on that roof for that period of time?
No, Your Honor. The testimony was that the DNA certainly could degrade as a matter of conditions. What there was proof of, which I actually haven't gotten into at all here, but what there was proof of is the people's experts testified to a couple of things that are very, very important here. I've spent this entire time showing you that there was no DNA evidence. But if you assume that there was a DNA match, which there was not, the people's experts conclusively stated that that would still not prove that Mayer had ever touched the shoe, which is what they needed to place him at the scene of the assault. And that happened in 3 ways. In relation to Your Honor's question, what Troy Holder and the people's expert O'Connor testified to is that DNA can be found on a surface a day after, a week after, a year after. He said it's not unusual to find DNA that has been on a surface for a very long period of time. So from that, we know that we don't know when the genetic material was actually deposited on the surface of the shoe. That's number 1. Number 2, the people's experts testified to the fact that you cannot, from looking at a DNA profile, know what the source of the DNA was. So you can't say that it's skin cells, which is what you would get from touch. It could be blood, it could be saliva, it could be any of a number of other bodily fluids or sources. That's number 2. And number 3, and most importantly, the people said that DNA on the surface of an object can never tell you that the person touched the object. And the reason for that is that there is something called secondary transfer and tertiary transfer. Primary transfer is, I touch this cup, I leave my DNA on the cup, we find it. Secondary transfer is, I shake your hand, and then you touch the cup, and my DNA is on the cup, even though I never came into contact with it.
And the third one?
And tertiary transfer, Your Honor, is I touch a doorknob, you come up behind me and touch the same doorknob, you touch the cup. I've never touched the cup or you, and my DNA is on the cup. And this is not something that is speculative. There's a University of Indianapolis study from 2015 that I actually cited in the materials, and that is a study that actually showed that in 85% of cases, what they did is they had 2 people shake hands and one of them touched the handle of a knife. In 85% of cases, the person who had never touched the knife, their DNA was on it. And to make matters even more interesting, in 41% of those cases, in which that happened, the person who had touched the knife, their DNA was not on it. So it was only the person who hadn't touched it whose DNA was there. Now, there are 2 cases.
I have to interrupt you.
Yes, Your Honor.
Part of the reason why the senior member of the bench gets the big bucks, we have to play the mean card also and cut people up. Before you sit down, prior to today, via correspondence, copy to your office, the people, Mr. Lieberman, requested and forwarded to us for consideration and as part of his anticipatory presentation to us, a copy of Elijah Foster Bay, People versus Foster Bay. We all know what the case stands for. Please quickly, since you don't get to rebut, comment in terms of how does that case play into our case, play into your presentation.
That case has absolutely no impact on this case at all. What that case is, it is a holding by this court that says that the Supreme Court providently exercised its discretion in denying the defendant's motion to exclude or conduct a Frye hearing to determine low copy testing and forensic statistical tool. For the court to find that it's not an abuse of discretion in an individual case on individual facts to refuse to order a Frye hearing is not tantamount to a finding that the evidence is reliable, necessarily, nor is it tantamount to a finding that counsel can't be ineffective for failing to request a Frye hearing in a particular case, nor is it tantamount to a finding that has anything to do with this case, because what I'm challenging, not only am I challenging the general reliability of FST and low copy.
And now I interrupt you. Now that challenge goes to legal and or factual insufficiency?
Correct, Your Honor.
Both.
Both.
Okay.
So
And in addition to that, your challenge, and now I'm trying to classify your presentation into subheadings, also goes to the weight of the evidence.
Correct.
Now, subdivide weight of the evidence within the scientific and factual and legal subcategories with regards to reliability, admissibility, and faulty methodology, which I believe so are generically the subcomponents of your presentation, quickly.
Correct. So with
The Lieberman is dying to get up here and address the court.
With respect to the legal aspect of it, I actually have two arguments, one of which I haven't addressed yet, but I'm going to go through very briefly, which is that on the assault conviction, there actually was an error in even allowing a person who was an aide and who was not the person who caused the serious physical injury to be guilty of the gang assault, because the statute requires that the person who is found guilty be aided by two people, which the Court of Appeals has made clear don't need to share the mens rea, but those two people are the aides. The principal can be found guilty if he's aided by two people, intends to cause physical injury, and thereby causes serious physical
The
injury.
theory of their case is that he was the principal.
Correct, Your Honor, but that is simply not borne out. So my point
Your
on the
position
theory-
is a reasonable clinical objective view of the evidence, notwithstanding the determination by the Nisi Prius court, is that this defendant was not any of the potential primary, secondary, or tertiary actors of the group of five that perpetrated this crime.
Correct.
That's your bottom line.
That's the bottom line. There was
Thank
no
you.
proof whatsoever.
People are up.
Thank you, Your Honor.
Good morning.
Morning.
Seth
Actually, good
Lieberman.
evening.
Right.
Go ahead, counsel.
There was so much in defense counsel's presentation that was off the record that I can't even begin to go into all the...
Well, to the extent that you have to part from a presumption of regularity that you can take to the bank is, we know what's in the record, we know what's outside the record, and we will consider only those parameters that are within it, if that helps you, in terms of facilitating your focus and the efficiency of your presentation. So utilizing that parameter, please.
Yeah.
I would
Counsel
not,
also-
one moment. I would not presume to tell you what to do, but make certain that you zero in, okay? We heard,
Absolutely.
and we are able to discern.
Absolutely, Your Honor.
Thank you.
Just, and also keeping in mind that lack of evidence is also a question in this case, especially in a circumstantial case. So some of the questions were geared toward what wasn't in the record, and what could have been posed, what questions could have been that weren't.
Well, you'd have to be more specific for me to know what you're referring to. But
go
in any event, the evidence in this case proved, first, that defendant's DNA was on the victim's sneaker. And this is all about looking at the numbers, and it's all about looking at one piece of evidence that defense counsel entirely ignored.
But the numbers are that you can't properly test if you're less than 100, 101, 125, depending on which testimony you accept. If you're less than that number of picograms, and you were.
No, Your Honor, there was evidence in the record that the medical examiner's office came up with a technique to amplify the amount of DNA such that you could use that test kit to test that DNA.
And they are, if I'm not mistaken, the only or back then, they were the only laboratory, public laboratory, in the United States of America that used that system.
Well, I think,
Is that correct?
No, that's not exactly correct. There were other labs.
That has happened where I have not been exactly correct.
No, well, because there were other labs in this country that were performing low copy number or high sensitivity testing. There's no question about that. That's the evidence in the record.
But not with your proprietary software.
But now you're talking about the forensic statistical tool. That's an entirely separate question.
Okay.
There have been Fry hearings with respect to high sensitivity testing in state that have held it to be a reliable technique. And experts, there was evidence in the record that DNA experts, a commission of DNA experts, had looked at the validation studies that were performed by the medical examiner's office with respect to high sensitivity testing and determined that this was a technique that could be used. So if just looking at the record in this case...
I have to challenge you. The fact that a technique can be used does not take anybody home with regards to pro-con propositions of proof or lack of proof, sufficiency of evidence or insufficiency of the evidence. You understand that, right? So that's not your best statement so far.
Speaking more specifically, the conclusion was that the technique was reliable and you could rely on the results.
And we found that in Foster Bay. The problem I've got is when Foster Bay came out, we didn't know, I don't believe, that, or it wasn't part of the record, that this technique would be, for want of a better word, decertified, debunked, I'm not sure, by CODIS and the FBI.
No, Your Honor. First of all, there is absolutely no evidence in the record that the FBI debunked this method. Defense attorney is pulling a factual statement out of the Collins decision. The facts of the Collins decision weren't in evidence. That's not part of the record. If the defense attorney wants to bring a 440 motion and raise all these facts, fine. But before this court is the record on appeal, which does not contain these facts purporting to undermine HST or FST.
Okay, so let's accept everything that you've just maintained as being the gospel, all right? Which I'm prepared to do. What does that have to do with the issue of the weight? In this particular case, let's say that it is somehow reliable, and I question that, but let's just say I don't question that. Get to the weight of the evidence. What was there in this case? This was a heinous gang assault. We all know it. Outrageous, right? We all know that. What convicted this? What was the evidence, the weight of the evidence?
Yes, Your Honor. The defendant ignores the validation, the summary of the validation report that was prepared by the medical examiner's office with respect to the forensic statistical tool. And one of the conclusions of that report, which the defense attorney completely ignores, is that when, based on their validation study, they concluded that if the suspect did not contribute DNA to the DNA mixture, the chances of getting a likelihood ratio of 100 or greater were approximately 1 in 176,000. And that is approximately, or less than, 1/1000th of 1%. So it would be an exceedingly rare event based on the validation study that when somebody did not contribute to the DNA sample, you would get a likelihood ratio of 100 or greater. In this case, there was a likelihood ratio of 695,000, which gave the trier of fact every reason to conclude that the defendant was a contributor of DNA to the mixture. That's just simple statistics.
That's with regard to the defendant and an unknown person. We knew who the other person was. It was the victim. So how is that statistic even relevant?
Well, Your Honor, if we're talking about legal sufficiency, as well as weight of the evidence, both of the people's experts, their testimony supported relying on the likelihood ratio of 695,000. That's just a fact. That was a number that you obtained using these methods.
What evidence is there regarding the impact of the limited pool? Let's say you have somebody from the Yucatan Peninsula, right? My understanding, they go back thousands of years, same gene pool, right?
This is right. This is exactly the off-the-record subject that.
But I'm asking if that question was asked. Was your expert asked that question? Because I want to know the answer to that. What is the gene pool? How does it impact on your statistics?
Your Honor, we didn't have to say anything about that because it wasn't the subject of the testimony. There was nothing before the trier of fact to conclude that there was anything about the pool that was a problem for this case. There was no evidence before the court regarding the gene pool of Hasidic people or any other group of people, nor, in fact, was while obviously the
defense counsel didn't challenge anything about
no,
it?
absolutely not. That was not an issue before the trier of
Did
fact.
the
It
defense
wasn't
counsel
raised.
have enough time to be able to prepare that theory?
Well, he had a whole week, and
A whole week.
and the expert had a whole week as well.
A whole week.
And how long did the office of the medical examiner have?
Well, Your Honor, if it's a question of figuring out whether to ask the question, to what degree does this database take into account these insular communities, that takes 2 seconds to figure out that question. So if it was really a question that this great expert that was relied upon in the Collins decision, presumably it wasn't that relevant a question. And
Let me see if I can. As you were listening to some of the questions that were asked, I'm going to part from the premise that you must have concluded partially that there were concerns raised in preparation for this case about, and I'll just select the one, in a case that involves, and all cases are serious in their individual universes, but in a case that involves the severity of the conduct that leads to the prosecution, and one of the main weapons of the prosecution is scientific evidence, more specifically DNA, the dumb moment of the presentation is, why wasn't this evidence given to the other side early enough so both sides, and I'm not saying, I'm not ascribing any mens rea, you understand that, but I want you to be aware that some of the questions that you're going to be perhaps listening to, which were already asked, are, was this a level playing field when this evidence get turned over? You've had it for a much longer period of time, and then in here your choice of words is 1 whole week. Well, 1 week would have gotten you into less of a hot water setting that the amplification of, a week is a long time when you say, you follow what I'm saying? There are factual and other nuances in this case that you have to recognize so that you can interpret the tenor of the question. So why don't you just
Yes, well, Your Honor.
Stop.
sorry, excuse me.
I'm not trying, look, we are never here to hurt anybody, and I'm not wearing a professorial hat. I want to make certain that, and if I do, well, too bad. I'm trying to make certain that your presentation is effective, to the point, so that we have from both sides what we need. You follow me?
I very much
Okay.
appreciate that. Thank you. With respect to the data being turned over on the eve of trial, it's impossible from this record to determine whether that actually prejudiced the defendant in any way, because you basically have to have Dr. Coyle testify that she did not have sufficient time to review the material. And there's no reason to believe that, given her expertise, that a week would have been insufficient for her to have mastered this material. And in fact, she came in, she had a lot to say, she seemed totally familiar with the facts, she had a PowerPoint presentation, so there's no reason to believe from looking at this record that the defendant was prejudiced in any way by the timing of the disclosure of the DNA.
Prior to trial, how long did you have that information? Not you personally.
I don't know.
I meant your office. How long did the district attorney's office have the information that was presented at trial? This, quote, DNA, or according to the other side, non-DNA evidence. How long?
I don't know the exact answer to that.
I don't need the exact answer. I just would like to know
I
approximately.
don't, off the top of my head, I can't even give you an approximate answer. But I go back.
Do you know that there were many requests for that material?
I know that there were requests, but the question is.
And what were the responses? Do you know the responses to those requests?
The specific responses?
No, not the specific responses. Any responses?
What's on the record, I'm not familiar with. I don't think that's information that's necessarily on the record. So I'm not sure how I'm supposed to address that.
Other than the turnover on the day of trial.
Excuse me?
Other than the turnover on the day of trial.
According to the defense attorney's letter. But again, there is no basis looking at this record to conclude that the defendant was prejudiced. That really is off-the-record material. That should be the subject of a 440, if anything.
If I may, can we change the subject for just a little bit? The question that bothered me from the testimony of Mr. Patterson was he was attacked by initially these three individuals. Video showed them to be Herskovic and two others, but not the defendant. It was one of these three who poked his eye. It was one of these three who threw the sneaker. Am I wrong on that?
No, because ultimately the victim expressed uncertainty about whether, in fact, one of the three people who were initially chasing him was the person who had poked him in the eye and removed the sneaker. And that was an incredibly chaotic scene. You had approximately 20 people surrounding the victim, kicking, punching him. People from the outside couldn't see what was happening. The victim, according to the evidence, had had a lot to drink, so wasn't necessarily in a position to make the most accurate observations. And
I think his blood alcohol was something like 0.2 over 0.2.
It was quite high. So even if you don't accept his, put it this way, even if you accept his testimony regarding the person who poked him in the eye, ultimately what we're really concerned about is the person who pulled off the sneaker. And the DNA evidence supported the trier of fact's conclusion that the defendant's DNA was on the sneaker.
So let's take your point to its logical conclusion. Let's say that the person who poked him in the eye was not the one who grabbed his sneaker. Well, then, how do you have a gang assault too if he wasn't, the person who grabbed the sneaker wasn't the primary actor?
Absolutely, Your Honor. The only reason why this victim suffered the injury that he did was because a group of men chose to surround him, prevent him from escaping, punched and kicked him, and rendered him helpless so that he was subject to being poked in the eye. And that is classic causation.
That does not answer my question. It does not answer
I'm
my
sorry,
question.
then I misunderstood
Gang
your
assault
question.
2 requires that the individual who is the primary actor is the one who caused the injury and who was aided by others.
Okay, Your Honor, I'm talking about causation. You don't actually, if you've contributed, if your conduct was a contributory cause of the serious physical injury, like any other crime involving that element, you will be liable. You'll be liable as a person who caused. The defendant's interpretation of that statute is all wrong.
I have to interrupt you for
Yes.
the following reason. We know what the indictment says. We have a theory of prosecution. We know what the evidence says. We understand the respective interpretations of what conclusions ought to be drawn from the evidence. We also know the number of members of, generically, of the grouping that surrounds the 5 that were identified during the presentation by your colleague on the defense's side. You seem to be saying, and if I'm not hearing you correctly, please enlighten me, that it makes no difference who blinded the victim because this was a gang assault theory of prosecution. But if from a factual sufficiency, legal sufficiency, weight of the evidence analysis, burden of proof beyond a reasonable doubt scope, the evidence in the judgment of the reviewing panel doesn't add up with regards to this particular participant, this particular defendant being anything other than one of the 50 or one of the 30 of one of the 20, what does that do to an affirmance versus a reversal? Do you understand what I'm positing to you?
Yes, I
So
believe
please
I do.
clarify for me.
This is a classic question of causation. If I'm holding a person, pinning him down, while my accomplice is kicking and beating him up, and I am preventing...
That's an acting in concert.
It's also causation.
You're all in. You're all in.
It's also causation, Your Honor.
That's not what the statute says.
The statute says nothing...
It says when with intent to cause physical injury to another person and when aided by 2 or more persons actually present, he causes
That's what all the
the serious physical injury.
That's what the murder intentional murder statute says. That's what the regular assault statute says.
This is
this is a
If the evidence comes out, if a reasonable interpretation of the evidence comes out that this particular defendant was 30 feet away or 20 feet away with a group of other members of this grouping, I don't want to use the word mob, but grouping surrounding the victim and presumably the 5 immediate actors, you're saying that's not a big deal. This is still an affirm. Is that what you're saying?
Your Honor.
I'm not connecting. Maybe my own shortcomings, okay?
He
But I'm not getting you.
He wasn't 30 feet away.
Whatever the distance was.
He was right next to the victim. He pulled off the victim's sneaker.
You may have an acting in concert, assault in the second degree acting in concert, but I'm not seeing the gang in the gang.
Well,
it's not the same.
First of all, there's nothing barring an acting in concert theory with respect to gang assault in the second degree.
Well, that's the question.
Excuse me?
That's the question.
No, it's not worded in a way that would bar any notion that you couldn't have acting in concert.
Defense counsel presentation, when it focused upon the 2 individuals holding the victim down, the ringleader and the other 2 that were immediately assisting the ringleader, not in the screening of the event, not in the holding down of the victim, but in the actual striking of the victim, the presentation by the defense counsel, and I'm not saying that presentation is going to take the day, but I need to hear what you say in opposition to that presentation,
No,
that those 5 did not include this defendant.
Right, but no. There were more than 5 people who were punching and kicking him. It wasn't just limited to those 5. The evidence was that the whole group of people who were surrounding him, or at least there was testimony to that effect, that supported the conclusion that that entire group of people surrounding him were punching and kicking him. It wasn't just limited to those 5. And the defendant was close enough, was right at the victim's feet to pull off his sneaker. So there was every reason to believe that he was one of the people who was punching and kicking him. So I think the evidence strongly supports, regardless of whether you accept the victim's testimony that the guy who pulled off his sneaker was the guy that kicked him and thrust his thumb into his eye, or just one of the people who was surrounding him, preventing him from escaping, punching and kicking him, and all joining together to cause him to suffer the serious physical injury. And that is classic causation. And just to address this whole notion of we don't know how the defendant's DNA got onto the sneaker, the only plausible explanation for that is that when the defendant gripped the victim's sneaker and pulled it off, that is how his DNA got on the sneaker. Because every other theory that the defense has proposed is
There is no match. Let's not forget that. You keep saying that his DNA was on the sneaker. Only statistically, only by some, not quadrillions, which is the way we usually hear DNA cases, you say his DNA, it's a possibility that it might have been his DNA on a sneaker, in a little piece of a sneaker on the side of a heel that was up on a roof that was found 6 days after the incident. There is a possibility. It is not his DNA necessarily.
Your Honor, it's all statistics.
It sure is.
The match is based on statistics, and this case has a very strong statistic, which I mentioned before, which was the validation study showing that if the defendant did not contribute DNA to this mixture, the probability of getting a likelihood ratio of 695,000 was less than 1/1000th of 1%. And that is proof beyond a reasonable doubt. 1 in quadrillion? That's
Wait,
beyond
the 695,000, that's with the unknown person not being the victim. Isn't that correct?
Right.
Isn't that correct?
Yes.
And don't we know that that other person is the victim? So isn't that 695,000 a statistic that is geared to impress the fact finder?
Absolutely not, Your Honor. Absolutely.
Because 695,000 impresses me.
It was what was based on
133, not so impressive. 695,000, more impressive. Quadrillions? Wow.
Your Honor, we're not experts.
Mm-hmm.
Experts testified at the defendant's trial. The people's experts said that you could base a conclusion on the basis of the 695,000 likelihood ratio, and that the likelihood ratio of 133 was another piece of evidence, but they did not suggest in any way that that number undermined the probative value of the likelihood ratio of 695,000. We are not experts. We can't look at those numbers and say with any certainty what their meaning is. we have to rely on the expert testimony that was provided at trial.
Let me, please finish your thought and then come to me. I don't want to interrupt you.
The expert testimony that was provided at trial, as well as the medical examiner's report, which the defense attorney has totally ignored.
Okay. Work with me on this, okay? I'm going to utilize something that has nothing to do with these facts and then come back to the point of the DNA and the reliability of the procedure that was used. So far, so good? Sure. Okay. You know Fahrenheit and you know centigrade, right? In temperature.
I don't know how to convert the two from one to the other.
That's not what I asked. But you do know that if we learn the formula, we know what this numerical Fahrenheit temperature has an equivalent in centigrade, because that is time tested numerically. And also, there's another scale, which is the Kelvin scale. But we know from science, and that has not been challenged, that you can correlate the Kelvin scale through a formula and its equivalent in Fahrenheit and its equivalent in centigrade. And provided that methodology is properly utilized, this Kelvin number corresponds to that centigrade number, corresponds to this Fahrenheit number. What's happening here, as I understand the presentation, is there is no equivalency with regards to the methodology that was used, the variables that were utilized in implementing this testing procedure, and the assumptions that were made. And if that bears out, Houston, you have a problem on an affirmance. Do you follow what I'm saying? Look, I'm not telling you what the outcome is. I'm trying to interpret what was said and what I need to hear from you countering what was said. Do you understand the analogy
Yes.
between Kelvin, centigrade, and Fahrenheit?
I
So,
think,
go at it one more
I
time.
understand what you're referring to, and I'll take a shot, and please tell me if I'm wrong. But
I would never presume to do that.
the defense made a lot of allegations how this was not properly done. The only basis for those statements was the testimony of the defense expert. The testimony of the people's experts entirely supported the conclusion that the assumption that it was a two-person mixture was a totally fine assumption. It also supported the conclusion that you can regard it as a two-person mixture and nevertheless properly with the FST throw all the alleles in there. There was no basis to conclude on the testimony of the people's experts that that was a wrong thing to do. And so consequently, just looking at the people's evidence, everything was done correctly. Nothing was done wrong. And again, we're not experts. I couldn't tell just looking at this whether it would be a wrong thing to do to say, oh, it's a two-person mixture, but we're going to throw all the alleles in. I'm not in a position to say that's wrong or right. But we had two people's experts saying that was a perfectly fine thing to do. And why should that would have justified the trier of fact's conclusion that it was a perfectly reliable set of numbers that ultimately the 695,000 likelihood ratio is a perfectly
Just one quick thing. In your opinion, was this a circumstantial case?
yes.
All right. That's my only question.
Okay. The trier of fact certainly knew what standard to apply in evaluating the sufficiency of the evidence in this case. And unless this court has any additional
Good?
questions.
We good? We good? Thank you both. Get home safe.
Your Honor, I know the court's rules very clearly, and I know that I've exceeded my
This
time.
better be good. It's not a question of exceeding it's not, it's,
I know.
what is it?
I have a bullet point, literally a bullet
What?
point, but
Don't-
there are 5
Counsel.
misstatements.
You're wasting time by setting the table.
Okay, I'm not going to set it up.
The table has been set. What
Misstatement
is it?
number 1, in bullet point, misstatement 1. The people opened by saying the defendant's DNA is on the sneaker. I'm not going to belabor the point, Justice Cohen made it himself, but I will point out that the people's experts themselves, I'm not relying on weight, in other words, the defense expert, the people's experts testified this is a non-deducible mixture from which no match can be made. That is on the record at page 113. People's expert testimony, number
Counsel,
1.
by the way, in case you have forgotten, you said that originally and we heard you the first time.
Correct, but
Don't- Counsel,
it's a misstatement.
If-
Number 2.
if we heard you the first time,
I won't
and
say
we
it
know the record, we know it's a mistake.
Got it. Number 2, the only plausible explanation to show how the DNA got on the sneaker is he pulled it off. Counsel said that. Now on that, he said that's the only plausible explanation. I quoted him. The people's experts said there are possibilities of secondary and tertiary transfer. That's on the record, page 803 and 804. People's experts. More than that, 2 cases that this court needs to look at, People versus Graham and People versus Person, directly on point, show the possibility of secondary transfer from which a case will be legally insufficient, and DNA on the exterior of a movable object like a cigarette recovered outside is legally insufficient. Number 3, the people stated that all the evidence about this not being suitable for upload into CODIS and not recognized by the FBI was off the record. Absolutely false. Record, page 731, 847. Those are places where the experts specifically recognized that this was not suitable for upload. Moreover, this theory that the court can't rely on what another court has held in Collins and Peaks is ridiculous. This court can rely on both primary and secondary authority.
Stop. When you walk out of here, he's still your brother in
Absolutely.
the... Stop.
Yes, Your Honor.
Stop means you're done. Now you're going to hear me.
Yes.
You're done. Not another word out of you, okay? He may be incorrect, but he did not state a falsehood. You're doing a great job. You both did, representing your respective. Let's not get carried away beyond, okay? We have everything that we need. We commend you both for your advocacy and for your intensity. Go home. Bye.
Thank you, Your Honor. Bye.
Thank you, Justice Cohen. Tell you what, we're going to take a